Hello, and welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Professor of Law at the University of Kentucky College of Law. My guest is Jacob Victor, Assistant Professor of Law at Albany Law School and Affiliated Fellow at the Yale Information Society Project. We will discuss his article, UtilityExpanding Fair Use, which will be published in the Minnesota Law Review. So welcome to the show, Jacob.
Thank you for having me.
Yeah, no, I'm looking forward to this conversation because I saw your paper when it came out on SSRN, and I was already intending to read it when you reached out to me because it looked really interesting, and I was not disappointed when I did read it. Really cool paper and thoughtful kind of approach you discuss toward the end of it. But before we talk about that, I wonder if for listeners who might not be so well versed in copyright doctrine, you could talk a little bit about what you mean by a utility expanding fair use and how a utility expanding fair use might be different from other kinds of fair uses under copyright law.
So I think the best place to start is just to provide a brief overview of what the fair use doctrine actually is. So the doctrine is an exception to the exclusive rights that a copyright owner otherwise has to exploit their work. And a defendant can basically raise it as an affirmative defense in an infringement lawsuit. And as long as they've satisfied certain doctrinal requirements, especially that related to the purpose and character of the use and the effect on the potential market, they can essentially use the work for free without permission of the copyright owner, even if the use would have otherwise been infringing. So the fair use doctrine is codified in the Copyright Act, but it's historically was a common law doctrine, and it's sort of developed in a common law like way with a lot of different additions being added by judges. And the most important addition of the last, I'd say, 20 years is this concept of transformative use. Which is basically the idea that when a new user adds something new with a further purpose or different character, which is a quote from a Supreme Court case on this, they can go ahead and use that use is a fair use. And what this usually means historically is that new sort of expressive works, new creative works that make use of existing creative content, but do so in a new way, essentially kind of creating a new work. So a parody might be an example. A use of a copyrighted advertisement in the context of a work of fine art. Those uses would qualify as fair use. So the reasoning here gets into kind of why we have copyright law to begin with, which, at least under U.S. law, in the U.S. system, the theory is that we want to be kind of incentivizing new creative works, right? So the concept of transformative use essentially steps in to prevent the idea, the very reason we give copyright to begin with, which is to provide authors the ability to kind of exploit their work for financial gain, so that they would have an incentive to produce works. It steps in to prevent that policy rationale from being overly undermined by those exclusive rights. So, I can take a photograph, use it in an advertisement, and get royalties off of using it in that advertisement, but I can't stop someone from then taking that photograph and using it in a work of fine art collage, where the theory is that that new work is essentially operating in a new market outside of the scope of my kind of conventional market. So I can still make money off of licensing that photograph for advertisements, but I can't make money off of using it off of that new use in a work of fine art. So in so doing, we're basically, I still have the original incentive to produce the work, but I'm not essentially stifling the creativity of other people. So that's kind of the original concept of transformative use as it was introduced by a 1991 Law Review article by Second Circuit Judge Pierre Laval, and then adopted by the Supreme Court in various cases. Or pause. adopted by the Supreme Court in Campbell v. Ake of Rose, a case from about 15 years ago. So in recent years, the concept has been extended into what the Second Circuit has taken to calling utility expanding fair uses. So this is a subset of transformative use, but I think it operates quite differently than the conventional type of transformative use. And what this utility expanding fair use concept essentially refers to is the use of large numbers of entire copyrighted works in ways that don't necessarily add new creative expression to them or repurpose them in some new creative way, but instead provide kind of an enhancement to users' ability to access the works or provide or access certain information about the works. And the Second Circuit has recognized very recently this is kind of somewhat different than the conventional idea of transformative use, but it's still covered under the fair use doctrine under certain contexts.
Well, maybe you could give like a specific example of or examples of utility expanding fair uses, either ones that courts have talked about or ones that are kind of out there in the wild, as it were, as a way of illustrating sort of what we mean when we talk about a utility expanding fair use.
Sure. So I think the best example is probably the Google Books case from a few years ago, which sort of took the concept as it had been introduced in a few other primarily Ninth Circuit cases in the last 2 decades and kind of provided a pretty good sort of summation of the development. So what that case talked about was the Google Books project, which scanned large, essentially almost every book in existence, and provides a searchable database to users. So they don't. To be clear, the project does not provide direct access to the books, but it does provide a way to sort of search every book essentially in existence, and find out maybe what page number your search term falls under, and also to get a little snippet of the actual book. So the court considered whether this kind of concept would be this kind of technology would qualify as a transformative fair use, even though it wasn't the kind of classical example like a parody where an author is taking existing creative work and adding sort of their own new creative expression. Instead, this technology was adding something, but sort of adding the usability and efficient access of these existing copyrighted works. And what the court said is that, like a creative, expressive, transformative use, the technology here still satisfied the fair use doctrines for 4 factors, basically arguing that the search tool function is sort of a purpose and character that is separate from the use of a book in a normal way as reading it and going through it. The search tool function is essentially provides a new purpose and character to the use, and more importantly, does not actually affect the copyright owner's financial market in a way that might make us worry about copyright's incentive function. And the theory there was that in using a search tool to search through a book where you're not actually getting access to most of the book itself, you would still need to go out and buy the book if you really wanted to kind of get the full creative expression embodied in the book. You can only use the search tools to get information about the book. And the Second Circuit, I think, held that this was what they would now call a utility expanding transformative use. The concept has evolved in sort of weird directions in the last few years, and that's sort of the bulk of what I talk about in the paper. So there's now been arguments made at the Second Circuit that any technology that not only kind of provides a new way of enhancing of getting new information about a work, but any technology that essentially enhances a user's ability to efficiently access a work should also qualify as a transformative fair use. And the Second Circuit has been kind of receptive to that argument and kind of skeptical. And a case that really, I think, clarifies that tension is a recent case called Fox News v. TV Eyes, which involved a technology that essentially creates a searchable database of every news program in text form. You can search for your name to see if you were mentioned on the evening news or something like that. And then once you've found a search responsive term, you could actually watch a clip of each of these, a clip of the original news broadcast up to about 10 minutes long. And in the lawsuit that appeared at the Second Circuit, and most of these cases happen at the Second Circuit because Second Circuit is just sort of the big copyright circuit. Ninth Circuit does a lot too, but part of the reason I'm talking a lot about Second Circuit cases is just sort of that's where things seem to happen. But in this case, the Second Circuit basically was considering whether this ability to watch a clip of these certain news searches was transformative fair use under the Google Books precedent and other precedents, and held interestingly that the ability to sort of access a piece of copyrighted material in a streamlined, efficient way, as this clip function allowed a user to do, should qualify as a transformative use, and actually, because of its sort of value in enhancing the usability of the underlying copyrighted material. But then did a sort of strange move where they said, well, the fair use is still not appropriate here because of the harm of the use on the potential on the markets of the copyright owner. Basically saying that allowing this type of use to go forward uncompensated would harm broadcast news copyright owners' ability to monetize their content. So at the end of this case, the Second Circuit decided that even though this was a transformative utility expanding fair use, it wasn't going to be allowed to go forward because of the market harm issue.
Well, I mean, it strikes me that when we think about something like both the Google Books case and the TV Eyes case that you just talked about, I mean, Google Books, the court said, well, this is a utility expanding fair use because it kind of takes the material and gives new functionality. But like, wouldn't it be even more utility expanding for consumers if they could read the whole book instead of just a snippet from it? And same with TV Eyes, right? I mean, as I understand it, the court said that the text descriptions were fine, but providing access to the underlying material was a bridge too far and infringing. But clearly it did make the material more accessible and was utility expanding for users. I mean, in the case, in sort of in relation to Google Books and to the TV Eyes database, were the copyright owners making that material available in that format to consumers themselves? And if not, should that matter for how we think about the nature of the problem from a policy context?
So it's a really interesting question. I think fundamentally, all of these cases and the very concept of transformative use, I think, is about balancing the public's interest in access for various policy reasons against sort of this copyright owner incentive function, which I'll caveat as there's a lot of empirical work that pushes back on whether that even really happens, whether authors need financial incentives in order to create, but it is sort of a fundamental conceit of U.S. copyright law. So it's something I'm going to kind of take for granted right now. But what I think transformative use does in all of these contexts is it basically says, well, are there policy reasons we would want to allow this use to go forward, and do we have to worry about harm to the copyright owners' markets? And if those two are in tension, how do we balance things out? And in the case of a kind of creative, expressive transformative use, that question is answered by the act of transformation. So I'll go back to my original example. I take a work of an advertisement and I repurpose it in a work of fine art. The fine art market is not really in tension with the market for advertising, the licensing of advertisements. So the very act of creation has, we would want it to go forward because we want to incentivize new creative endeavors, and we don't really have to worry about harm to the copyright owner's markets because that market is not necessarily affected by the new use. That logic, I think, also holds for something like Google Books, which is only really making use of the which by virtue of only providing a search function is expanding utility in a way that we should care about, but is still not jeopardizing that basic market for buying books and the like. In TVIs, I think we saw sort of a more direct tension between those two goals, where you have a technology that's utility expanding in its access enhancing in its use in sort of expanding consumer access to this content. But the court, I think, was worried about what this would do to the broadcasters or content owners markets for providing that content directly to consumers, and basically decided that this was too much. This was too much access to warrant what is essentially a free license through the fair use doctrine. Whether it should, you also asked whether it should matter whether the copyright owner is providing access. I think it should. Fox, it was a little bit unclear in Fox News v. TVIs whether they were. They claimed that there was Fox claimed that there were ways of accessing the content through its own websites, but also I think essentially claimed that this would be the type of technology that would be logical for Fox to sort of develop and license to, because it's essentially a new dissemination market. It's a way for users to sort of get access to content when they're no longer watching TV at night. Like they're going to go up and use the search tool, and that's how they're going to access Fox's content. So I think they did. I have some issues with the court's reasoning there, but I think they did paint a case of market harm that was more compelling than what the plaintiffs argued in Google Books, where they claimed that even just the existence of a search tool would harm their markets.
Yeah, I mean, if I may, it sounds like a situation where we see these new technologies or these new formats that generate a lot of positive externalities or have the potential to do so. And in theory, sort of parties could sort of work it out through licensing, but transactions costs and so on have created a market failure, or kind of inclined toward a market failure that prevents the kind of bargaining that would let that happen. Sometimes fair use seems to be able to solve the problem, but it seems like in your paper, part of what you're saying is that fair use isn't necessarily always the best tool, at least as currently constructed, in part because it's kind of an all or nothing tool. Play that out a little bit. Why is that a problem for using fair use? Or why might fair use not always be best attuned to sort of fixing this particular policy problem?
Sure. So I think it's right to think of it as a market failure. I wouldn't say it's just about transaction costs. I think you're right to say it's also about kind of positive externalities and the social value of these uses, and why we might actually want some uses to occur for free, and so, as long which a licensing market would usually presumes a price, but why we might want something like Google Books to occur for free because of the maybe high positive externalities of that use, coupled with the fact that copyright owners are not really being financially harmed in a way that would make us worried about copyright's incentive function. But I think in cases where those two are more in tension, where there is some tension between the sort of social value of the use and the incentive function of copyright, a better mechanism would be to actually set a price, which fair use doesn't do. Fair use just provides free access to the user. So in the paper, I argue that a better lens to apply here would be compulsory licensing, which is a sort of different limitation that is employed in U.S. copyright law that basically takes away the control of the copyright owner, like fair use. The copyright owner can't say no to the use, but still provides the copyright owner with some financial compensation. In the paper, I basically say that these types of utility expanding fair uses have actually been addressed by a regulatory compulsory licensing system in the past, and essentially what we're seeing here is the kind of the the rise of these similar types of policy concerns in new markets in ways that have been traditionally addressed, or at least historically sometimes addressed through compulsory licensing in other markets.
Well, so maybe you could talk about one of those compulsory licensing regimes so listeners would have a better sense of sort of how it actually works in practice and why it solves, or at least partially solves, some of the market failures or inefficiencies that might otherwise be expected to arise.
Sure. So my favorite example. So compulsory licensing is notoriously complicated, and there's this regulatory apparatus in Washington that administers the existing compulsory licenses that I've written about in other work, and it's pretty convoluted. So I'll give a pretty high level explanation. But one example of these compulsory licenses was created in the late 90s for the use of sound recording copyrights, sort of music embody, recorded music copyrights essentially by new digital radio technology. So think of Pandora. Satellite radio was also covered at the time, and essentially, if you look at the legislative history of that act, which is called the Digital Performance Rights Act, what Congress seemed concerned about was similar to what we were seeing in these kind of utility expanding fair use cases. So basically, you had copyright owners were exploiting their copyrights in CD markets, MP3 markets, things like that, selling that music to the public. And all of a sudden, this new technology came around, digital radio, that was going to provide a new way of accessing that content. And Congress could have done a few different things. They could have basically said, well, this is just going to be a conventional licensing market. If digital radio stations want to use this content, they'll have to pay a license, negotiate and pay a license. And Congress actually did do that for music streaming, like services like Spotify, but didn't do that for digital radio. The second approach might have been to say, actually, we're not going to make digital radio stations pay royalties at all. We're going to exempt them from copyright protection. And that has actually been historically the story with non-digital radio, with broadcast radio, which has not had to pay licensing fees to copyright owners. The theory there being that broadcast radio does not really compete with kind of conventional dissemination markets, but instead provide sort of a boost to those markets. You put your song on the radio and then everyone goes out and buys the CD later on. Congress also wasn't really satisfied with that explanation when it came to digital radio. I think rightly realizing that this is a much more easier way to kind of access music directly in a way that may make it that people would not need to go out and buy CDs in the same volume as they might have otherwise. So the solution that Congress came to was imposing a compulsory licensing regime that basically allows any digital radio station to make use of music, sound recording copyrights, as long as they pay a government set fee to the copyright owner, and this fee is set every, I think, I don't remember exactly however many years, but it's set through regulatory proceedings every few years. And something that I think is interesting about this, the way these fees, at least historically, were set, was that they weren't about, they actually tried to account for the type of social value issues, the kind of positive externalities that we were talking about before. The rate setting regulators were actually tasked with trying to identify a rate that sort of recognized the value of these new technologies and expanding access to the public, while simultaneously trying to ensure that copyright owners were adequately compensated. And this, of course, is a highly subjective enterprise, but I think it sort of illustrates the same type of policy balancing that we're seeing, maybe not happening as well in the context of fair use, which to me suggests that maybe the better lens to apply to this utility expanding fair use phenomenon would be something like compulsory licensing.
Yeah, so one thing you remarked on in the paper that I thought was really interesting was that when these compulsory licensing regimes are created, there is this kind of looming risk of kind of too much regulatory back and forth. But it seems like in a lot of cases, parties end up sort of resolving these disputes about rates and so on their own, and so there isn't as much kind of regulatory activity as we might predict there to be. Is that a fair reading of your take on what has happened in the past? And if so, why do you think that happens?
It's a really interesting question. I think it's a somewhat fair reading on what's happened in the past. I don't think it happens that well in the current music compulsory licensing system, but it can happen, and it's sort of a question of institutional design and regulatory design. But there has been a lot of work that sort of shows about the difference between kind of a liability rule or a property rule. A compulsory license essentially being no, the kind of classic liability rule in the Calabrese Malamed framework, where the government is basically stepping in and forcing, allowing the use to occur, but requiring compensation. Um, and there's been some work done by several scholars about how sort of the shadow of liability rules can actually impact licensing and bargaining. So some people have looked at sort of other regulatory contexts and shown that when there's sort of a prospect of a court or regulatory agency stepping in to set a price, that will actually galvanize licensors and licensees who may otherwise be recalcitrant for various reasons or be holding out for a higher price that's problematic, to reach a private bargain, so as to not have to resort to the use of that regulatory price setting mechanism. And I think that would be an interesting, I think in this case, if we were to kind of add on a compulsory license option as a supplement to fair use for those cases where we have some kind of utility expanding transformative use, but the market harm to the copyright owner is too great to allow for fair use. If we were to add on a compulsory license option as sort of the next step, it would be an interesting question as to whether courts would actually have to do that type of complicated rate setting very often, or whether just the prospect of a court stepping in to set a price might galvanize licensing between companies like TBIs and the copyright owners that may have resisted licensing to them.
Well, so in the paper, you kind of suggest that there was a political backdrop against which previous compulsory licensing regimes were created. Sort of what was or what has been the sort of paradigmatic relationship between various market players that has resulted in the creation of a compulsory licensing regime? Do you see similar kinds of kind of commercial or institutional relationships in relation to the kinds of circumstances that might be arising in future utility expanding fair uses? And sort of like, what do we really practically need for a compensatory licensing regime to actually be created?
Sure. This kind of gets to the heart of how copyright law is created these days, and there's been a lot of work about how really this is kind of a political battle. Almost any new copyright law policy is a political battle between copyright owners trying to essentially get as much money as possible, and those that are trying to use that content trying to pay as little money as possible. I think that's probably a bit of an overstatement, but that is kind of the fundamental battle that gave rise to a lot of the kind of existing compulsory licensing regimes. And it's important to, I think, recognize that political reality, but it doesn't necessarily mean that the mechanisms that the law that emerged were necessarily not reflective of copyright policy, because fundamentally a lot of what copyright law policy is about is balancing between kind of the financial needs of those copyright owners and the use of sort of new uses and new users. So I do think in the case of the utility expanding fair uses, we probably have a similar backdrop. So the question is, like, why would Fox News, the plaintiff in Fox News v. TBIs, not want to license to TBIs? Maybe they wanted to bankrupt TVI, so Fox could step in and create sort of this new service. Maybe they were too worried that if users use this service, they would they would stop watching the evening news and they would lose their advertising revenue. There's some evidence that Fox was willing to license to TVIs, but only if TVIs signed a fairly restrictive kind of content moderation agreement, like a non-disparagement, essentially a non-disparagement agreement to Fox's content. So basically, what you have there is Fox trying to kind of extract whatever suits its business purposes, and in this case, deciding that licensing to TVIs does not suit its business purposes. TVIs went ahead and used the content anyway, hoping that it could get a fair use ruling. In that case, you have TVIs basically saying, "Well, if we could use this content for free, that would be great for us too." So I think an ideal legal solution would basically step in and say, "Okay, how are we going to split the baby here?" And to me, fair use doesn't seem really able to do that. So the question then would be, what, as you said, what would be the kind of best way to go about doing this? And to me, I think we could potentially work within the existing copyright remedies regime to make this happen. So let's say you have a case like Fox News v. TVIs. There's a close but no fair use ruling. The court recognizes transformativeness, but finds that the market harm precludes a fair use ruling. I think the next step then should be, okay, how can we craft a compulsory license rate that embodies sort of the policy goals that were discussed in the initial fair use finding? And that's not how things usually work today. Usually, if you lose a fair use determination, you go on to the normal kind of infringement proceedings, and if you are found to have been an infringer, there's usually an injunction, there's usually statutory damages, things like that. What I'm essentially proposing is, rather than that being the next step, we think about imposing a remedy that essentially creates an ongoing royalty obligation between the parties.
Yeah. Well, so if I may, I mean, it seemed like the framework you're setting up makes a lot of sense to me, where we have, a new technology that's going to generate positive externalities, going to generate profits of some kind or another. And there's parties on both sides. And really the question is how they're going to split up the profits. And maybe in many cases, it's hard for them to agree on how those profits are going to get split up. And if that inability to come to a meeting of the minds on the deal means that the technology isn't available to consumers, that's a problem that we can maybe fix through this kind of liability rule related problem you discuss. I wonder how that works in a situation where there aren't necessarily profits to split up, though. I mean, while I was reading your paper, I couldn't help but think of, like, for example, the Internet Archive's recent National Emergency Library, right, where was also, I mean, I think fairly characterized as, an effort to engage in a utility expanding fair use, but objected to by copyright owners on the ground that, well, you're just providing the whole work. How does that fit into the paradigm you're describing here? And, how, when courts are presented with that kind of situation where there really isn't a revenue stream to split up, how should they think about it?
Yeah, I think it's kind of the heart of the problem here. And to me, this suggests why fair use is still important as part of the analysis here. That I'm not arguing that we should just replace fair use with kind of a liability rule with damages, which some other folks have sort of suggested in other work. I'm basically saying that we need to supplement fair use with a compulsory license, but fair use should still be the initial inquiry. And the reason there, I think, is that fair use is actually really good at weeding out kind of the types of things that you described. So another, I think a good example would be the use of copyrighted works to create accessible forms for the visually impaired, which cases have held is kind of a classic form of fair use. And to me, that actually makes sense under the kind of utility expanding paradigm as well, because what you actually have there is you have sort of groups coming in and turning existing works into accessible formats, in a way that the existing markets weren't really doing, right? Either because the markets were too small or because there just wasn't there were information problems that for copyright owners to understand that there was demand here. And what the courts have essentially held in those cases is that there's no revenue to share here, basically. Like there was not a market that was being exploited because copyright owners presumably did not view this as a financially viable market. Someone came in and started doing this service for this population, and we're going to let them continue to do that at no cost. So to me, the example you describe, I think, assuming that the court was considering kind of like the time limited emergency version that I think is sort of on the table, that to me would still qualify as a fair use and still warrant receiving kind of this zero price, what is essentially a zero price license, and would not need to kind of go into this compulsory license analysis of questioning, of how to sort of divide up the revenue.
Well, so Jacob, in closing, I really thought this paper was a clever way of trying to resolve a problem that we see cropping up in a copyright context over and over and over again. Every time new technologies, increase accessibility or increase usability from a consumer perspective, and sort of how do we ensure that we have a system that doesn't prevent positive developments from being implemented and benefiting consumers, which ultimately is the goal of, or at least in theory, the goal of copyright policy. But I guess I also couldn't help but wonder, reading the paper, should the very problem that you're describing and trying to solve encourage us to reflect on sort of the entitlement of copyright owners to claim these, or claim a share or the lion's share of these positive externalities to which they're contributing content, but not necessarily implementation? Like, is there any level on which you think that the sort of the need to solve this problem ought to make us reflect on sort of how we do and think about kind of the propertyness and the entitlement of copyright owners to make these claims in the first place?
I think absolutely. Part of, and this is something I've suggested in another article, but part of, I think, the reason why we, tolerate things like compulsory licensing in copyright more than we probably would in other forms of other property regimes is the sort of policy drivenness of the initial entitlement to begin with. The idea that a copyright owner is getting what courts often call a limited monopoly to exploit this work for a limited amount of time, for the very specific purpose of providing this kind of incentive to create culturally valuable works. And built into that entitlement is all of these exceptions that are designed to further balance that goal against other policy goals, whether it's access, whether it's ensuring additional follow-on works, whether and there's all sorts of other policy reasons we'd want to weigh against that, and a lot of these kind of market regulatory tools like compulsory licensing, I think, are drawn out from that sort of initial balancing act in the entitlement. And I think sort of the task of digital copyright policy going forward is trying to kind of fine tune that and push back on this idea that copyright is sort of an immutable property entitlement that deserves no exceptions or limitations, which is a kind of the talking point of a lot of folks in the creative industries these days. And I think whether that's shortening the term or whether that's creating other types of kind of market regulations, that the goal of this project is sort of opening up that discussion and allowing for a little bit more inquiry into what are we actually talking about when we talk about weighing the balance between incentives and access that is at the heart of kind of the U.S. copyright system.
Awesome. Well, Jacob, thanks. It was a really cool paper. I enjoyed reading it, and I look forward to your future work in the area.
Thanks very much.
It's your bargain day.
Hey, Bob.
Bargain day.
Hey, Bob.
Bargain day.
Hey, Bob. Everything's hey, Bob. I was standing on the corner, just mostly killing time, when all at once I noticed a funny kind of sign. Ladies' dresses, hey, Bob. Men's trousers, hey, Bob. Shirts and blouses, hey, Bob. Everything's hey, Bob. We're going out of business. We're selling out at cost. Come right this way, it's a bargain day. Our clothes are all hey, Bob.
It's your bargain day.
Hey, Bob.
Bargain day.
Hey, Bob.
Bargain day.
Hey, Bob. Everything's hey, Bob. I went up on the second floor to have a look about. They had a special feature on that nearly knocked me out. Ladies' girdles, hey, Bob. Gowns and pajamas, hey, Bob. Men's long handles, hey, Bob. Everything's hey, Bob. We're going out of business. We're selling out at cost. Come right this way, it's a bargain day. Our clothes are all hey, Bob.
It's your bargain day.
Hey, Bob.
Bargain day.
Hey, Bob.
Bargain day.
Hey, Bob. Everything's hey, Bob. I met a little gal the other day. She was cute as she could be. I went crazy over her and she's crazy over me. Now I'm half off. It's a bargain day. And she's half off. It's a bargain day. We're both half off. It's a bargain day. Everything's half off. Come on, honey, and give me your hand.
Let's go find the preacher man.
Hey, Mr. Preacher, what's the license called?
It's a bargain day, son. Half off.
It's your bargain day.
Half off.
Bargain day.